Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about is how to establish paternity in a Connecticut custody case. So allow me to share my screen. I'll show you the relevant forms. So if you're going to file a custody application, you will see this section down here, section 2, that says you have to submit certain documents in order to establish paternity. So this does not apply to divorce cases that involve children because there is a presumption that the any children born during the marriage are the biological children of both parents. So these documents are not necessary. They're only necessary in custody cases in which the parties are not married. So the section 2 says, I understand that by the first scheduled date of this case, I must file the applicable accompanying documents from this list that prove the existing legal relationship between the parents and the child or children named in this application. And it goes on to talk about redacting certain information. So by that first court date, you can file a copy of the birth certificate of the child or children naming the parents. So if you have a birth certificate that names both parents, who are the plaintiff and defendant in the custody case, it's pretty simple. You submit that. You could also have a court order or decree naming the legally responsible parents, including an adoptive parent. So if you've been to magistrate court for child support in the past or juvenile court or probate court, there you might have a paternity order or a paternity adjudication naming the parents. If you have that, you can file it with the court, and that is sufficient. Another document is a court order or decree. That's what I just talked about. I skipped a copy of a properly executed, finalized acknowledgement of parentage. So that is a form that if you go to the website of the Department of Public Health, it'll, show that an acknowledgement of parentage form is a sworn statement voluntarily completed by the parents at the hospital at the time the child is born, which presumably you don't have, or at a later date at any local office of the Department of Social Services. So why I said you probably don't have the form that was completed at the hospital is because if you had done that, you probably have a birth certificate. So if you need to get the acknowledgement of parentage form, you have to actually go to the Department of Social Services or the Department of Public Health to complete that form. So back to the custody application. The other, if you have a surrogacy agreement, that's going to be pretty rare, but if you have that, you can provide that. Or other documents showing that the child or children was or were born during my marriage to the respondent. So if you have, if you're filing, you can technically file a custody application if you're married without filing a divorce. So if you're doing that, you could provide your marriage certificate and establish that you're still married, or any other evidence sufficient enough to prove legal parentage of the child or children. So that's a pretty vague statement there. So what probably makes the most sense is to provide a certain affidavit based on a certain statute. So Connecticut General Statute, Section 46B-488, it's the presumption of parentage statute. And that says, subsection 3 says that the person jointly with another, or sorry, let me start at the beginning. A person is presumed to be a parent of a child if the person jointly with another parent resided in the same household with the child and openly held out the child as the person's own child from the time the child was born or adopted and for a period of at least 2 years thereafter, including any period of temporary absence. So basically, if you've lived in the same household as the other parent and the child for at least 2 years, and you've told the world that that child is your child, then there is a presumption of parentage. So the document you would want to submit is an affidavit, basically summarizing what is in that statute. So this is a sample affidavit that you can complete, and it says that, I'm over the age of 18 and believe in the obligations of an oath. That's kind of a necessary part of an affidavit. And that I have resided jointly with Jane Doe, whoever the other parent is. Obviously, this top section should be the caption that goes with your case. That I have resided with Jane Doe in the same household with the minor child or children, and then insert the names and dates of birth of the children, and have openly held out the child or those children as my own from the time the child or children were born and for a period of at least 2 years thereafter. So you can use this sample affidavit. Obviously, you're going to have to fill in the names and change, it to singular or plural, depending on how many children there are. And you can submit that as your documentation. That should be sufficient to establish paternity. So those are the basics on how to establish paternity in a Connecticut custody case. As usual, if you have any questions, please contact our office. And if you are looking for representation in a Connecticut family law case, we would invite you to contact our office as well.